It is 11 a.m. in Washington, where the Supreme Court is hearing a challenge to the law used to prosecute hundreds of January 6 defendants.
Our Scott MacFarlane joins us now with more analysis on today's argument. So, Scott, can you tell us more about the arguments that we heard this morning on both sides?
You're not hearing a lot of discussion of the attack itself, the rioters. You're hearing about this obscure federal law and U.S. code, which has become a very common argument in the January 6 cases. The code involves obstructing an official proceeding. It's an obscure term, but it's been used in more than 300 January 6 cases, and some of the defendants have argued it's not appropriate in the context of the U.S. Capitol riot, that it's more related to financial crimes or document destruction, not a mob attack. Most of the federal judges in Washington, D.C. have dismissed that claim and say, no, it's fully appropriate. But one agreed and let this go to an appeals court. The Supreme Court has taken it up, and during extended arguments late this morning, you heard them press attorneys from both sides. Should we be using and allowing this charge in the context of January 6th? If they strike it down before the session ends here in June, would impact not just the hundreds of January 6 defendants who've pleaded guilty or been convicted or have been charged with that crime, but Donald Trump faces that charge as well. In his special counsel 2020 election conspiracy case, he's pleaded not guilty. Just as a reminder, Anne-Marie and Vlad, the official proceeding alleged by prosecutors is the January 6th electoral vote count, which was disrupted and obstructed for several hours that day.
Right. We were saying earlier, Scott, that this is a statute of the Sarbanes-Oxley Act, which was first used specifically, famously, in the Enron case. It had to do with things like destroying documents. And as you point out, that's what the justices, or at least that's what both sides are arguing. In the obstruction of the proceedings in Congress on that day, this destruction of documents, could that be applied to what some of those January 6 rioters did? So, Scott, what are you sensing from the justices, the kinds of questions? Because it's very archaic and it's very arcane. If you're not a lawyer, it's kind of hard to follow. But how are they reacting?
Yeah, you do get them pressing both sides, so it's hard to read into the questions, because when the attorneys representing the argument of the January 6th defendant was up there, all the justices, in their own way, were pressing him about his claim. The U.S. Solicitor General's up there arguing on behalf of the Department of Justice, and they're pressing her on her claim. So it's risky to give you a gut read or a sense of the questions, but I can tell you this. They're drilling down on one issue in particular. Does this statute, which calls for the obstruction of an official proceeding, involve documents only, or more than just that? Does it involve the obstruction of, things that are supposed to happen, that the government wants to have happen at a certain time at a certain place, a proceeding? And the U.S. Solicitor General, as the morning concluded, was making the argument that's exactly what Congress intended, and this is a perfect fit for what happened in this once-in-a-lifetime event. January 6th has no precedent, so it's not surprising that there's no precedent of this type of case being filed before.
All right, Scott MacFarlane, thank you.